This is Today on eNCA. Our special focus starts now. Well, Senzo Meyiwa's murder shocked the nation, and the resulting court case is turning out to be quite gripping as well. This week on eNCA Sunday Focus, we take a closer look at the trial of those accused of his murder. I'm joined by eNCA's Silindelo Masikane and a few legal experts to weigh in on this. Firstly, I have Khumalo's lawyer, Magdeleen Moonsamy. There you see her on your screen, as well as Afriforum's Barry Bateman, who joins me. They've been monitoring the proceedings on behalf of the Meyiwa family. So let's get started. We don't have much time. We had planned on an hour sleep, but we now have half an hour thanks to the speech that was taking place. Not everyone has been following what has been happening with the trial. So by way of bringing us up to speed, I'd like you to talk to us about what has happened in this week. It turned out to be one of those weeks that Vladimir Lenin must have had in mind when he said, you know, sometimes a decade can happen in a week. Yeah.
Look, I would have liked to take you back to April, where we saw the arrest of Advocate Malisa Latefo, that just to lay the ground for you in terms of the kind of allegations we're seeing coming out of courts, instead of not even inside courts, court corridors. These are all sideshows that we're seeing taking place outside of this trial. But this week alone, we've seen some explosive submissions in terms of the defense and them laying the ground in terms of how they're going to defend their clients. They're starting with the fact that they believe that the crime scene from the very beginning was contaminated, it was manipulated, and that whatever the forensic investigator found, who's the first witness for the state, that is Sergeant Thabo Mosia, that was all staged, that was all planted for him to find there, but also they're questioning how this crime scene has actually been handled. Let's take a listen.
Potential witnesses of the accused 1 to 4, they complain that we have been exposed to the harassment, to the intimidation. It's a common cause that this court knows that we have been harassed, starting with me as a counsel of 1 to 4, my attorney, and all those interested parties. In our case, for accused 1 to 4, we got intimidation, we got the threats. We are not saying Netflix or the 1010 film production intimidating our witness. We say they are exposing our witness to intimidation, to serious threats to their lives.
The other concern is that you represent an entity which is not a media house. And I would be interested for you to respond to that, which is not a media house, which is here as a business concern to gather material that it intends to use within the concourse of its business venture. And therefore, when permission was granted for the media to be in attendance in this trial, it did not include business ventures that want to do the one or the other in pursuance of the objective of their business.
Shall I address you?
Yes.
Well, firstly, all of the mainstream media who are attending these proceedings and who record all criminal proceedings or civil proceedings in the country are business ventures. There is no non-profit company present in court today. The SABC, eNCA, Newsroom Africa, these are all business ventures. They derive revenue, otherwise they wouldn't be here. They wouldn't be sustainable. So we don't understand why one is being singled out and not the others.
Was the life of Senzo Robert Meyiwa saved by the people who removed him from the scene, primary scene?
No, I won't be able to answer that, my lord. I was not there.
You don't know?
Angeke ngikhoneke noma ngikwazi ukuphendula lokho ngithi bakwazi noma bakhona yini ukuthi bayihlenga impilo yakhe ngoba ngangekho lapho.
It's reasonable you don't know, you are not the eyewitness. Yes. The same eyewitness will further testify that the firearm used to shoot Senzo Robert Meyiwa by Khumalo came with Longethwala, and the firearm is a revolver. Any response?
No comment on that.
All right, so those are some of the excerpts of what came out of court. Obviously, a lot more came out, but because of time considerations. Let me bring in Magdeleen Moonsamy on behalf of Kelly Khumalo. Magdeleen, I imagine that, you know, there's a reason why you had kept a watching brief over these proceedings, and I suspect those reasons came to materialize. But did you at all expect that they would come to materialize so early and by way of, you know, an argument and a foregrounding by the counsel for the accused 1 to 4 that actually a witness will come at some point and make these claims against your client, Kelly Khumalo?
Thank you so much, Tulasizwe. The first thing is that there was no anticipation of my client, these allegations that have been leveled, that such would be leveled. And I can give you the following. One is that we were confirmed by the NPA and various other stakeholders that my client is not a suspect and may not be called in as a state witness. I have been watching brief over the matter for a couple of years now. This is because of the fact that my client has to constantly undergo interviews, interrogation, etc. regarding the matter, and has requested me to then be there to watch over what is the nature of questioning that is being placed. I'll give you a very single example. We once attended an interview with various stakeholders, including ballistics, etc. And one of the police officers who claimed to be at the hospital on the evening, on that fateful evening, later revealed that he was in fact not there, but was just simply putting my client on test. Now that by its nature disclosed that there are things that we are unaware of, and we remain unaware of. And being a watching brief allows myself to be able to become aware more clearly as to the nature of what is the proceedings, but also to be present and to participate through submission and engagement insofar as what then happens when my client goes from a victim, a state witness, and now being alleged to be an accused person. Now that is the reason. It was not anticipated, Tulasizwe, at all. And this is why we are intending to fight back.
All right, I'll check in with you in a moment on how exactly you intend to fight back. But let me bring in Elton Hart from the UJ Law Clinic. And Elton, just the extraordinary, well, I don't know if it's extraordinary, you tell me. Was it extraordinary the way this allegation was made in that it didn't come from a witness who was in the witness box saying, my lord, here's my understanding of how it all transpired, but it came in the way that it did, you know, being foregrounded and almost as a preview by counsel. Does this happen often in criminal trials? Elton?
Or is it Barry? You want me to cover?
Yes, yes.
Okay. Normally, like you would put it, if you know that you're going to call a witness, obviously you need to then bring that witness later on. If you're going to put a version to an accused person or to a witness, you need to then call the supporting witness to say that this witness will testify this, and then you can bring that witness in. Obviously, this, it looks like it's evidence from the bar that Advocate Tefu was giving evidence from the bar. But at a later stage, if Advocate Tefu comes and he actually now brings this witness, this eyewitness that he alleges saw everything that happened, that he alleges that Ms. Khumalo now shot the deceased person. If he brings that witness, then that witness will be in the witness box, and then people can cross-examine him, examine him in chief. That can happen, but how he did it, it looks like he's blindsiding the NPA, and also most probably blindsiding Ms. Khumalo in this instance. But obviously, you cannot dictate to a legal representative how he needs to represent his client. So that is now what transpired there. Maybe the way in which he did it people might find it a little bit offensive. Of course, he had a chance to speak to his colleagues before say, I'm going to make these revelations in court. And what are you guys going to do? Maybe they could have handled it in a much more sensitive way, if one can put it that way.
Yeah. Barry Bateman, let me bring you in at this point. I don't know. There seemed to have been a lot of focus, and not just seemed. In fact, there was a lot of focus on the manner in which the SAPS handled the crime scene, issues such as forensics. And I think many of us got a glimpse into what does or doesn't happen by way of preserving a crime scene as well as evidence. Just from your side, watching this trial on behalf of the Meyiwa family, what did you make of that particular area of focus, as well as this bombshell allegation that came through Advocate Malisela Tefu?
Yeah, good afternoon to us as well. Well, first off, on the handling of the crime scene, sadly, it's something that we are all too familiar with in South Africa. I mean, you just got to cast your mind back to the Oscar Pistorius trial, for example, and we saw several anomalies and irregularities that came out there with items apparently being moved and not properly documented and the like. So that was, I suppose, the last big high-profile matter we've had. We're in another one, and we're dealing with questions related to how a crime scene was processed. Now, of course, the defense is going to make a lot of noise. They're going to kick up a lot of dust as they're trying to demonstrate that this was there was no integrity in the sealing of this crime scene or the gathering of the evidence. But, you know, from our perspective and our understanding of where this case is going to be going, we think this evidence at this particular stage is not of much value. There might be some irregularities that are picked up. What we're eagerly awaiting is for the state to start leading the evidence, which we believe conclusively link the accused to this particular crime. And this is forensic-related evidence, that was found, like the bullets and the analysis thereof, which we understand positively link the accused. Moving on to your question about this, I suppose you called a bombshell, a revelation, it certainly was peculiar that the defense counsel would put this to a witness, but he provides no further evidence. We don't know who this eyewitness is that he's going to be calling. He didn't tell the court who the eyewitness is. He hides behind this claim that his witnesses are being intimidated. But, you know, it doesn't, inspire much confidence in that, in fact, this eyewitness will, in fact, be called, because having, understanding of the affidavits that are already in the docket, the eyewitnesses that have deposed to affidavits make no such claim that Kelly Khumalo, in fact, pulled the trigger. So it certainly came as a surprise. It was peculiar, and we await to see if indeed this witness will be called to support what was put to the witness who was in the box this week.
Yeah. Sleep, before I come back to you on the where we stand now around the issue of a trial within a trial, which Advocate Tefu now insists on, let me go back to Magdeleen while the point is still hot. Magdeleen, you said earlier on that you will be pushing back against this particular allegation. And at the same time, I'm also wondering if we are saying that, as Elton was saying earlier on, that it's unorthodox in that it may be seen as evidence from the bar. One wonders why there wasn't such an objection from the NPA. But importantly for you, how exactly do you plan on pushing back against this?
I think the first thing is it is indeed very premature that this was raised. There was, to some indication, Advocate Tefu had contacted me during the course of last week, the week before, and he did indicate to me that there is something that will come, and how will then but not specifically the details. I explained to him that whatever he decides to do, he needs to act within the process of the court. To present such an allegation, which is something that I had not known until I was informed via the media and watching the proceedings. It then occurred to me that this is premature. The courtroom has now become a stage or some kind of a platform for another purpose, as opposed to presenting a legal position in its proper entire value and manner. Now, when you say how do we intend to fight back, one, we have the option of submissions. But secondly, there has been some speculation that has run around about the intentions of the instructing attorneys as well as Defence 1 to 4 counsel, of which I take exception, not just for myself. Remember, Tulasizwe, my client has been under public persecution and the court of public opinion ever since the knowledge of Senzo's passing became public. And as a result of that, one has to consider then, what do we do? Because we've remained silent for a very long period under all manner of allegation, accusation. Remember, Tulas, it started with the killers being bought. If we remember, let's remind ourselves of where the history comes from. It started with defeating the ends of justice, of which there was no charge. It came to perjury, of which there was no charge. Now it is my client had allegedly, accidentally killed Mr. Meyiwa. Now for myself, if one has to be rational, one would take into consideration that these are not allegations you flail around in order to seek attention and thereafter assume that I am intimidating witnesses and making counsel for 1 to 5, etc., uncomfortable and making witnesses uncomfortable. These witnesses are known to the defense. These witnesses are known to the state. These witnesses are not known to myself, except for those that I am aware of. But there is no way that we are going to sit back. We have the options of submission. I'm still interrogating, because after the allegation against my client was leveled, there were further allegations leveled against myself, which then accumulated some of the issues that we have to face and process.
Sure.
So indeed, we will be taking a stance and we will start with submissions, but that will not be the only posture that we will be taking in this matter.
Slee, let me bring it back to you then. Towards the end of the week, Advocate Defo was now insisting that there should be a trial within a trial. What's that all about now? It sounds like, you know, there are now issues of jurisdiction even that are being raised at this point after the trial has gotten underway.
Yeah, so it was quite strange because, I mean, on Friday we were expecting the cross-examination of Mosia to continue by Advocate Zandile Mshololo for accused number 5. But before we could get to that, Advocate Defo stood up to say that he's got some more submissions to make and saying to the judge that he believes that the continuation of this particular trial and cross-examination of Mosia was a futile exercise, saying that back when his clients actually made their first appearance in the Boksburg Magistrates Court, they did not have their rights read to them, also alluding to what he says are confessions obtained by the state using assault against his clients, saying that he believes the state intends on using these confessions from accused 1 and 2. But then the judge stopped him right there to say, but no such evidence has actually been introduced at this point. And the judge saying that he can't actually deal with this kind of evidence when it has not actually been submitted. At that point, Advocate Mshololo asked for protection from the court, saying that she doesn't understand why Defo is trying to instruct her on how to do her job, and that she believes that she still has more questions for the state's first witness. And so the judge then ruling that the trial would continue and that if Defo wanted the court to entertain such an application, he should file papers.
Elton had 2 questions for you. One, is there a dynamic that is unique to the legal professions that you are also observing? Certainly as a bystander, I'm looking at this and thinking there's certainly something going on here in that the objection I heard coming through was about, you know, it being unfair on Advocate Mshololo that Advocate Defo cross-examined and completed his cross-examination, and while Advocate Mshololo is busy with her cross-examination, these objections that include objections around jurisdiction are coming to the fore. But you would know better. Is there a dynamic you are observing?
Yes, indeed. And for me, it's like normally when we have different defense teams, I would think that the defense teams would work together in a coerced move to actually now destroy the state's case or poke hole in the state's case. What I'm seeing from Advocate Tefo at this point in time is that he's interrupting his colleague while she's busy with cross-examination. And that is not supposed to happen. It's unethical towards your colleague. It's disrespectful, if one can put it that way. Let her finish her cross-examination, because whatever she's putting to the witness has nothing to do with the violation of their constitutional rights and how they were handled at the Boksburg Magistrates Court. And indeed, the judge was right in saying when we deal with the evidence, the confessions, if somebody is going to introduce the prosecution, that they say, this is a confession you made that say you actually shot the deceased, then he can now bring that application. But while his colleague is cross-examination, let her finish her cross-examination. That is what I expect from a fellow legal practitioner to do so.
Yeah, I'll come back to my last question and you'll have the final say because I'm almost out of time. Barry Bateman, let me bring you in into this conversation. So what's your sense, Barry? One of the things that concerns me is that, for instance, the whole issue around translation coming as it does after the witness, the police investigator, has delivered a large chunk of his testimony in English without translation, and issues around legal representation. Could all of these issues come back to haunt all of us, or perhaps the parties that are involved in the end, in that they become issues of procedure and the question of whether or not, you know, these could be brought up in review to say, I mean, a lot went wrong in this trial.
You know, on the issue of the translation, you know, I don't think so. I think what happened there, and I was sitting in court when the judge recommended this, the witness was coming under significant pressure during cross-examination. And, you know, we often seen it, you know, when the questions start getting a little bit more difficult to answer, you require a little bit more time, and sometimes an interpreter will be able to buy you that time, to give you time to think. You know, it is in the record, it's on the record, you know, now he's getting the appropriate translation and the matter is able to proceed. I don't believe it is going to come back to bite. But, you know, it has been a very interesting week. You're talking about Mr. Tefo on his feet during the cross-examination of his co-defense counsel there. It was certainly something I'd never seen before. You know, the decorum of the court is something that must be upheld. And to be interrupted your fellow colleague like that certainly does raise some questions. The judge even having words about Mr. Tefo just walking out of the courtroom without excusing himself, putting on his robes while, you know, in the courtroom itself. So, you know, despite what's actually being presented to the court, the other side issues certainly raise many questions with how things are being handled in this courtroom. And what Slee touched on there, this application that he wants to bring to show that his clients weren't properly read their rights, you know, that's going to be another contention, I suppose, another issue that we'll have to deal with once this cross-examination is concluded. Will we actually ever reach the end with Mr. Tefo is certainly a question to be considered.
Elton Hart, very quickly from you. The glimpses we've gotten of forensic investigation in South Africa, as South Africans who don't interact with the system on a daily basis like you do, you and Magdeleen actually, what are we to make of it all? Is this an aberration? The amount of evidence that was either not observed or not gathered by the investigators on the night in question. Is this something that happens on a daily basis, except now this is, you know, within the full public glare, the glare of the public?
Obviously, sometimes it happens that forensic investigators don't get all the evidence from the various crime scenes, but this one is in full glare of the public, and I think what Advocate Mshololo is doing is currently she's now poking holes into the testimony of Sergeant Musiwa, and I think that is what a good defense lawyer would do, is to show that this witness on the stand evidence cannot be believed, and that creates doubt, and when there's doubt you must acquit. And I think Advocate Mshololo is right in the corner there and saying keep him there and make him concede to a lot of things that he thought is not important to court. So he played the court's role. He was supposed to say, here's all the evidence, court. You decide which ones is relevant to you. So Sergeant Musiwa, someone on the crime scene, decided, okay, I'm just going to give the court this ones that I think is relevant. And that's where the problem lies with this evidence for me. And I think Advocate Mshololo, if she keeps it going at this rate, this case might end up in a 174.
All right, I've got to thank you for your time. I'm completely out of time. That's the panel discussion that we've had. Silindelo Masikane of eNCA, Barry Bateman from Afriforum, Magdeleen Moonsamy representing Kelly Khumalo, as well as Elton Hart from the UJ Law Clinic. That will do it for this discussion. I'm back with more for you at the top of the hour. The eNCA Corruption Scorecard coming up next.